SJC-11370, Commonwealth versus Self.
Good morning.
Morning.
May it please the Court, my name is Assistant District Attorney James Kerr from Middlesex. With me this morning is Trial Prosecutor Assistant District Attorney Heidi Gossel. The motion judge in this case erred in holding that the examination and diagnosis language in Section 13 of Chapter 123A requires an in-person interview of a respondent unless the respondent refuses. And this Court need look no further than the specific language used by the legislature in Section 13.
So you're saying that in the future, if you're right, a QE does not have to interview the defendant, even if the defendant wishes, I mean, not the defendant, the respondent, even if the respondent wishes to be so interviewed?
That's correct.
They could just say, I don't feel like doing it.
The legislature was very careful, I think, in orchestrating this this scheme, in that they were clear about who could conduct the examination and diagnosis, why these individuals were qualified to conduct them, what information they could use during their examinations, and when, during the process, these reports must be filed. They did not speak to how.
Well, what's fair about the idea, if I understand the way the system would work, is that if the examiner wants to interview and the respondent refuses, you have the report, but the respondent can't put in anything of his own expert, right?
In circumstances where the respondent refuses to be interviewed,
Right.
he cannot then produce his own expert testimony which is based on his own personal interview. That's correct.
If he wants to be interviewed and he gets a court order to that effect, the QE can just say, sorry, I don't do that. Tough luck for you, right?
Well, the qualified examiners here it's a unique circumstance in which they're court-appointed gatekeepers of the process. And so to the extent that a particular qualified examiner deems that an interview is not appropriate in a given circumstance where the legislature has not specifically required that happen, the process has to continue. Now, that's not to say that the fact finder should or even could rely on that opinion at the trial. Well, should, I should say.
Are you suggesting that the opinion would not be admissible at trial?
No.
That's a possible remedy here?
No. Well, I think it's a possible remedy. I think that the question that's posed by this case is what is one of balancing and fairness in the process.
Right.
I would submit that based on the plain statutory language of Section 13, an interview was not absolutely required under these circumstances, and that given the court order, there might be the need for remedy at trial.
And what would that be?
It could be a range of things. I would suggest that simple cross-examination would be more than sufficient. However, it could.
So then the QE says, here are all the medical reasons why I don't. I mean, that doesn't really. Why is that equal to prohibiting the respondent from putting in anything if he doesn't choose to be interviewed by the QE?
Well, the remedies could include the exclusion of this expert at trial, but the bottom line is that the Commonwealth should be allowed to proceed based on the fact that we have one qualified examiner who complied with not only the statute, but anything that the court might have ordered.
Can I just clarify the legislative history of this? I think you are arguing that the including interview came at an earlier stage and that the word examination without the modifier including personal interview That was enacted in what, 1969, early 70s, something like that, right? Am I correct? Later.
With
And that was, you're arguing that that's purposeful.
that's correct.
Can you tell me whether that is the time at which those, I'm not sure what they're called, but one of them is the static testing that was more factor-based came into being? Because I understand that there is currently a controversy about how much clinical subjective observations may be able to accurately predict as compared to these other factor-based exam tests. When did that first arise?
I honestly can't say, Judge. I'm not aware of when those actuarial factors were introduced. I can say that they are currently a part of at least both of the examinations that occurred in this case, both factored in the static 99 as an actuarial factor, but also both QEs were very careful to also include the clinical portion of the examination, which is a review of this particular individual's history, treatment records, etc.
Now, as I understand it, the Commonwealth needs to have these two reports. It only needs to have one that, in fact, opines that the respondent is sexually dangerous. But the Commonwealth has to make a decision whether or not to go forward with this based on what the qualified examiners say. Wouldn't it be in the Commonwealth's not just interest, but in the execution of its duties to have as accurate and full information as possible as to whether or not this person is sexually dangerous? And the Commonwealth, we've already said, is the one who's in charge of driving this process. So if you have a qualified examiner who refuses to go forward with an interview that the defendant is willing and able to be present for, why not replace that qualified examiner with one who will, in fact, do the interview?
That is, in the Commonwealth's position should not be taken at all to imply that an in-person interview might very well be best practice, and it might be within the court's discretion to replace an examiner who refuses.
I'm sorry. You say your position is not that it's best practice, or we shouldn't take that you.
It's not.
I'm sorry if I was not clear. It might be best practice for an interview to take place.
So the real question here is, what do we do when it hasn't? If we conclude that an examination of this sort ordinarily implies a personal interview, and the Commonwealth has not done that, at least with respect to one of the examinations, what's the proper remedy? You're saying dismissal is not.
That's correct.
Where you have two reports filed, one of them with a personal examination, one of them perhaps not, maybe defective later on, but dismissal is not the remedy.
That's correct, Your Honor. And the reason is that looking to the Ganji, Kennedy, Parra, Gross line of cases where this court has sanctioned the dismissal of the Commonwealth's petition based upon a violation, in each case, those violations either caused or were caused by extending the 60-day period of the respondent's time at the treatment center. The respondent does clearly have a significant interest in liberty interest, and that is the governing factor behind the nearly automatic dismissal in those cases. Here, the respondent's liberty interest was not infringed upon, where the Commonwealth still filed for trial before the 60th day. So I apologize.
I just want to ask you this. Let's say this problem had arisen before, and let's say that it's understood that, in fact, you're going to need two QE reports where an interview has taken place. As a practical matter, would you be able to, not this case, because events happened when they happened, but can you make sure that that happens within the 60 days? Even if you, in other words, just in terms of pure administration, is it difficult to ensure that you could do that?
I apologize if I don't understand
well,
that.
no, you shouldn't apologize. I should apologize to you. Well, I guess what I'm saying is, it seems to me in this case, one might say the remedy is replace the doctor who wouldn't have the lawyer in the room. But at the time that occurred, I take it there wasn't enough time to find somebody else to do it and still make that 45 and 60-day requirement.
That is, I mean, the Commonwealth filed for trial, I think, on either the 49th or the 50th day. There was some wiggle room. I think, to be sure, that's not, I mean, 60 days is not a lot of time to begin with to get all this together. 10 days might very well not have been enough. But if this issue had been brought forward sooner, at the very least, there's some, potentially this could be the case where those extraordinary circumstances justify the period of time beyond 60 days.
Wasn't though their effort by the lawyer for Mr. Felt to tell the district attorney, the prosecutor, that this qualified examiner wasn't cooperating? 3 times she rescheduled. She advises him not to follow his lawyer's advice. Wasn't that all something that the prosecutor knew was happening?
There was an email exchange, and I believe that the last word from the district attorney's office was that if the respondent had an issue with the way that the qualified examiner was conducting the examination or dealing with the interview, that she should bring it up to the court, which she did do, but not until well after the 60 days had expired here.
Do you think that there is room in the statute for the Commonwealth in these circumstances to file a motion to have the interview with the doctor who did conduct the interview, have that video recorded and made available to the doctor who refused to conduct an interview with defense counsel present?
Well, the statute certainly doesn't speak to that specifically. I mean, there are a number of cases dealing with audio recording, video recording of these interviews. Usually, I think it's for purposes of trial. Subsequently, I think that in the abstract, such a video recording might be helpful to another qualified examiner, but I'm not sure that the statute specifically would permit that circumstance.
So the court does not have authority to, at least in your view, the court does not have the authority to allow that kind of a substitution or of a tweaking of the interviewing process?
Well, I think that the court does have substantial discretion in terms of resolving issues of fairness and balancing with respect to evidence at trial. In terms of this initial process, we're still at the gatekeeper stage in this case in dealing with the statutory provisions at that point. And here, under Section 13, where the respondent has not previously been found sexually dangerous, or at least is not currently sexually dangerous, the statute only requires examination and diagnosis by 2 qualified examiners. It's not a circumstance such as Section 9, where the respondent is at that time sexually dangerous and is the moving party and is therefore putting his or her mental state at issue by saying, I'm no longer sexually dangerous. That's the distinction here.
But you're going to lock this person up for his life, or could be. I mean, there's big stakes here. Are you suggesting there's less stakes when you're classifying than when you are trying to get out?
Not at all, Your Honor, but I am saying that the Commonwealth is, and the legislature, with respect to designing these provisions, is in a different position. And it's that with Section 13, this person has not previously been found sexually dangerous. We cannot write into the statute language which would compel this individual to waive their statutory waive their therapist, psychotherapist privilege. Conversely, in Section 9, where that individual has been found sexually dangerous and is committed from 1 day to life, the state has a substantial interest in ensuring that these sexually dangerous people are treated and kept as long as they need to be kept. And so under those circumstances, where the respondent, again, is the moving party, there's the Commonwealth and the statute is in a different position with respect to compelling the interview. I see my time is up. I will rest on my brief. Thank you very much.
Thank you.
Thank you, counsel.
If it please the court, Mr. Chief Justice, David Hirsch representing Mr. Felt. Let's say that Dr. Vasher, the QE we're talking about in this case, had not only refused to do an interview, let's say she had said, I just know that all these sex offenders reoffend and are all sickos, and that's the basis of my report. Doesn't review the records, doesn't do any of the things required by Section 13 of the statute. Well, the Commonwealth has its 2 reports, but would anybody think that this was a basis for filing an SDP petition?
But the difference, I mean, the statute says it has to be an examination. Your hypothetical has the doctor doing nothing.
Well, that's where we get into the question of what constitutes an examination. And it includes a bunch of things that are statutorily enumerated, well, not only an examination, but other things that are enumerated in the statute, such as the records review. The examination, I think we have to look at what an examination means in case law, in statutes involving not only sexually dangerous persons cases, but in criminal cases and other kinds of cases.
Well, in criminal cases, if a defendant does not choose to rely upon his own statements made to a psychiatrist, can nevertheless proceed with an insanity defense and introduce psychiatric testimony in which there has been no interview with his own doctor and himself, and the Commonwealth can do the same thing. There is an opposition to insanity evidence by an expert who has not interviewed the defendant. It's not as good, but it's not inadmissible.
And if that's quite true, Your Honor, but in that case, there has been no examination. And
well, there's been an examination. There hasn't been an interview.
That, I think, is a key issue in this case. What constitutes an examination? Case law gives us lots of hints about it. For instance, in Connors, Commonwealth versus Connors, this court held that the qualified examiner can rely on a records review where the defendant, the subject, refuses to participate. Why did the court say where the defendant refuses to participate? Why include that as a qualifier in the decision? It only makes sense if the interview is part of the an inherent part of the examination, because otherwise, if it's not part of it, what the court said, there's nothing else for the defendant to submit to. There's no other way in which the defendant can manage not to participate. He has no way of keeping the qualified examiner from looking at his records. His only ability to not participate is by not being interviewed. Therefore, under the language of Poinsat and of Connors, it doesn't matter whether certain things are in footnotes or not. The thrust of both cases goes to one specific fact. This guy refused to be interviewed, and that makes it clear, I think, given the way the cases were decided, that the interview is a necessary part of the examination unless the defendant stymies that. Now, in fact, I think that's one interesting thing in the Commonwealth's brief. In the questions presented, it argues that the issue it argues that the issue here is whether an interview is required other than those times when the defendant refuses to cooperate. But then the cases it argues, Poisson, Connor, are cases where the defendant refused to cooperate. They don't even address the question that the Commonwealth's asking in that way. The cases go far beyond Poisson and Connor's. Again, in Poisson, the court said that the Commonwealth can't make the defendant submit to an examination by the Commonwealth's expert. But in Cowan, the court said that the Commonwealth's expert can still do an evaluation based on the records review. So what constitutes the examination? If the defendant doesn't have to submit to the examination, but there can still be an evaluation, by process of elimination, the examination must at the very least include the interview.
Let's assume you're right. Let's assume that there's an entitlement of a respondent to an interview and that your client was denied that entitlement. You could have, on the same day or the next day after it happened, gone to the judge and said, Judge, this QE is violating your order.
And, Your Honor, that would have been appropriate and necessary were it the defense's job to make sure that a proper interview, that a proper evaluation got done. But I think this court has made it clear over and over again that that's the responsibility of the Commonwealth. Now, in this case...
But it's not the Commonwealth who chose this QE. It's chosen, I gather, it's in theory court appointed. I gather DOC essentially appoints somebody.
DOC does.
So the prosecutor can't say, you're fired, I'm going to put in somebody else. That's not the prosecutor's prerogative, is it?
But this court, well, first of all, I don't know if they can do that. They can certainly go to DOC and say, help, this QE is messing up our case. You got to get somebody else fast. Or help, you got to tell this QE she must cooperate or she jeopardizes our case.
But you also could have gone to the judge and said, Judge, you gave us an order which said that in your discretion, I can be there for the interview, and this QE is in violation of the order.
Two answers to that. First, once again, the court has said it's the Commonwealth's responsibility to make sure it gets done within the 60 days. Therefore, I don't think it is that is defense counsel's duty. Secondly, let's look at what defense counsel did do here. She made every effort to work with the prosecutor to see that that the rules were complied with. First, on the 14th, the day that Dr. Vasher filed her report, defense counsel called the prosecutor and complains about Dr. Vasher's conduct. What does the prosecutor say? I have no knowledge of that. 2 days later, she calls again. She sends a follow-up email to the prosecutor. The prosecutor doesn't respond for 6 days, and when she does, doesn't answer the question of whether she really, of whether she really believes that Ms. Kelleher, the defense lawyer, actually told her, oh, don't worry, I'll sit outside. At that point, we're 57 days into the process. We're 57 days into the process because of the Commonwealth's failure to do anything about a problem it knows about. At that point, it's really too late to do anything else. That can't be attributed.
But even then, you didn't go to the judge. You didn't go to the judge till after the 60 days were over.
I'm sorry, I couldn't hear.
You didn't go to the judge until after the 60 days were over.
That is And there's no responsibility for the defense to do so because it's not the defense responsibility to get these reports produced. It's the Commonwealth's, even though they are technically not the agents, the
Well, I mean,
appointers of these
generally, when
QEs.
you have a court order which says that you're entitled to this, and the person does not give you that entitlement, and you don't take any action, one could argue that you've waived that entitlement by not seeking to enforce it.
Oh, but counsel did seek to enforce it, doing what I think is what should have been the simplest, easiest way to enforce it, going to the prosecutor repeatedly. Now, there is I think the court's, Your Honor's question, once again, improperly lets the Commonwealth off the hook for what is their responsibility.
Is your client, I know he's being held pending this, he's not still serving any criminal sentence?
Correct, Your Honor. He has been held solely because of this matter. The Commonwealth, well, the other cases involving mental health exams, the rule's the same in criminal cases, in mental health cases. Did the members of the court receive the first of my two 16L letters yesterday?
Yes, I did.
I cited cases like Ostrander and Vathi Sangh. In both of them, this court discusses the defendant's duty to submit to the exam. Again, the only way in which the subject can submit is by going along with the interview. Otherwise, the term is meaningless. The Blaisdell court describes what a defendant will be called upon to say in the course of a competency exam, therefore making it clear that the interview is necessarily part of that exam. In Sargent, court assumes that an evaluation includes an interview. We begin by noting that the defendant has submitted no affidavit or other evidence demonstrating that he did not have access to his attorney during the period leading up to the interviews with the qualified examiners, or that he asked Quinones, one of the QEs, to reschedule the interview so that he could consult with his attorney. We have the same thing in Johnson. If you look in mental health law under GLC-12312, which I cited in my 16L record, there too, it says, talks about the examination not being possible. What does it mean for the examination not being possible? Well, it says the mental health worker can then rely on the basis of facts and circumstances. What are the facts and circumstances other than a records review, knowledge of what's going on? The only thing that's an examination about that is the interview.
Mr. Hirsch, if in these circumstances, had the Commonwealth filed a motion for a videotaping of the other qualified examiner's interview and then made it available to the qualified examiner who refused to go through with the interview, would that pass muster under the statute?
I don't think so. It's an interesting question, which I had certainly never thought of before today. But I think, given that there has to be the use of independent judgment by both examiners, I don't think it would be proper for when there's supposed to be two separate determinations by QEs, for one QE to make her determination based on the questions that the other QE chose to ask. The difference between a Section 9 and a Section 13 case, I think, cuts the opposite way from the way my brother has stated it. In a Section 9 case, the court actually, the QE actually has less need for a personal interview because in that case you have years of records about how this person has responded to treatment, whether this person's done treatment, how this person has behaved on the unit in the treatment center with the people who are supposed to be observed by the people who are supposed to be under, let me withdraw that last part of the sentence. In the Section 13 case, what do we have? We may not have any clinical records at all other than those 60 days in which there seems to have been no contact between the QEs and the treatment center personnel who are supposed to be under their supervision. The Commonwealth states that Poisson is really talking about the difference between actuarial and clinical evaluations. I think that's wrong. I think that Poisson uses the term clinical in two different contexts. One is the difference between the two kinds of evaluations. The other, in a separate part of the opinion, the issue that applies here is the clinical component, which requires more than, say, a static 99. Unless there are further questions, I'm out of time.
Thank you, sir.
Thank you.